everybody.
Good morning, my lord. My lord, may I mention one case, your lordship, if your lordship permit me, from the daily list. Lordship.
Yes.
Item number 17 and 18, your lordship. In this case, we have to file rejoinder to the counter affidavit. Therefore, only 1 week time may be given, your lordship.
Item number?
I will 17 with 18. WPT 2043 of 20 and 2051 of 20.
When I was going through the file, I thought that you should have filed rejoinder, but you never mailed any prayer for adjournment. So we read the files now.
I'm sorry. I'm extremely sorry, your lordship, for the inconvenience caused to your lordship.
Please mind it in future.
My lords, I appear for the respondent state, my lords, in seal number 18, WPT 2051. And even I thought that it would be argued today, but it seems that Mr. Ashok Kumar Yadav's name has been inserted inadvertently only because a copy was served, but state is not a party, my lords. Anyway, my lords, if my lords are not taking up it...
Convert credit transition and then interest being claimed under section 50.
My lords, and the jurisdiction, in our case, my lords, in the brief that I have, my lords, it is a case of refund adjustment. And that refund order has also been passed by central authorities.
Yes, Lordship. In this case, the central authorities have passed the order.
Very well. How much time do you require?
Only 1 week, your lordship.
Next time onwards, inform beforehand. You see, a lot of pressure upon us.
I came to your lordship.
I returned at 7:30 from the court after a meeting, and then went through all the order sheets and then the files. So,
yes, your lordship, my mistake is there.
2 weeks, as prayed for by land counsel for the petitioner to file rejoinder affidavit. You had in fact sent the list of dates also, so that was also for the other side.
This was sent
in item 18 for the other side. Mr.
In the both cases, I am appearing.
So Mr. Amit Kumar in both cases. Mr. Sarona Mittal's name should be deleted. GA1's name should be deleted.
Ashok Kumar Yadav's name should be deleted, my lords, because state is not a party, my lords. He's been served a copy.
With the name of Ashok Kumar Yadav, GA1 be deleted as state is not a party in item 18. In 17 also they have impleted. There also the name of Mrs. Mishra should be deleted.
Well, I don't have that brief, my lords. I'm not aware.
They have impleted formally state of Jharkhand, but basically it's a grievance against the CGST.
Yes, sir.
Mr. Agarwal, you don't have any grievance against state of Jharkhand.
But yes, but we have made the party, therefore the name of the state councils are appearing, lordship. If your lordship.
If they are unnecessary parties, we will delete their name. Let the name of Mrs. Darshana Podar Mishra, AG1, be also deleted from the cause list. Stop. The nomenclature of the writ petition. In the array of parties in the writ petition, item 17, the name of state of Jharkhand be also deleted as the grievances of the petitioner are directed against this central GST authorities. This is the case after 2 weeks.
Obligement.
In item 14, Ms. Samrita, you have sought an adjournment.
Not item 14, but item 19 I have sought an adjournment, your lordship.
And in item 14, the other side has perhaps mailed for an adjournment.
Yes, your lordship. I have been informed that late at night that they will be seeking time in that matter.
Anyway, we'll see when it is called out.
Ji. But in serial number 19, I have prayed for an adjournment, your lordship.
why are you asking for adjournment in this matter again?
Your Lordship, for the reason I need to seek certain instruction, and plus I'm not ready with the file, Your Lordship. Other matter listed today at serial number 21, Your Lordship. I'm ready with that matter, and it will take another 1 to 2 hours. Serial number 24, Your Lordship. So I was ready in that matter. I sent the compilation, the argument of mine, and the list of dates. I'm ready in that matter, Your Lordship, and it will be taking time in that matter. For that purpose only, I was just.
Item 19, Malikia. Request for adjournment has been made through mail by Land Council for the petitioner, Ms. Amrita Sinha. It is prayed for that the matter appear after 2 weeks.
May I just pray, Your Lordship, on 7th of March onwards, many cases are listed. So I can pray after Holi. Already
After
many
3
cases are there.
After 3 weeks.
Much obliged.
Lordship, serial number 14, I'm appealing for the respondent, Lordship. In that matter, I prayed for adjournment.
Serial number 14, Ms. Rakhi Sharma, and Council for Respondent and adjourned. Stop an email was also circulated yesterday. Ms. Amrita Sinha. As prayed for, matter is adjourned for 3 weeks.
Much obliged, Lordship.
On the this, our orders will be paid. Item 1, review number 121/2019. The Abhishek Kumar for the police matter. The round number for the police.
This matter, perhaps, Honorable Mr. Justice Deepak Roshan.
Milords, in similar cases, Milords, yesterday 2 cases were taken up, Milords. Milords is posted it before the appropriate, but this is.
Which one of us, Deepak Roshan J within bracket, is not a member?
Much obliged, Milords.
Item 2, tax appeal number 21 of 2021, along with item number 3. Mr. Ram number.
May please, Manoj. Due to some inadvertent, I had mentioned last time that the original order is in tax appeal 21, but I have found the original order is in tax appeal 19, Manoj. So that is perhaps one defect, Manoj, which is remaining. There are multiple tax appeals, so Manoj, I mistakenly said it is in tax appeal 20. It was in tax appeal 19, the original order, Manoj.
You should also verify about the tax effect in this case.
Manoj, I'll do that, Manoj.
Because this is not pursuant to the audit objection. That is
Manoj.
the one exception which has been carved in 2018.
Manoj. I'll take instructions, Manoj, on that also.
Yes.
I was praying, Manoj, since the original is in tax appeal 19, Manoj, this defect may be ignored, Manoj.
Earlier, on 20th October 2021, defect number 4 was ignored on the submission of Learned Counsel for the appellant that the original communicated copy of the impugned order has been filed in tax appeal 20, number 20 of 21, and the same is a common order. Again, the respondent for different assessment years. Our staff office has again pointed out that the impugned order of tax appeal 21 of 2021 varies from ITA case number in the impugned order of tax appeal 20 of 21. Stop. Then counsel for the appellant submits that inadvertently it was submitted that the original communicated copy of the impugned order has been filed in tax appeal number 20 of 21 instead of 19 of 2021. Stop. The said defect may be ignored. Taking note of this fact. Accordingly, the said defect is ignored. Let this appeal be tagged along with tax appeal number 19 of 2020. and counsel for the appellant shall seek instruction as to the tax effect of the impugned order, whether it falls within the related limit. इसमें 20 में तो इफेक्ट नहीं है हाँ? इसमें है
Manoj, I think Manoj, defect number 2 is there in the next item, Manoj, tax appeal 20, which relates to that the appellant is different in this appeal, Manoj. Manoj, the appellant normally before the IT80 is the assessing officer, but the appellant before my lords under 260A is the principal commissioner. Will be ignored, Manoj.
appeal number 20 of 2021. The defect relating to name and details of appellant is ignored as the appellant herein is the Principal Commissioner of Income Tax Central 1.
Manoj, if all defects are ignored, Manoj, if notices can be issued, Manoj, I leave it to my lords.
About 19 of 21, whether notice has been issued.
My lords, in 19 and the other matter, 18 notices have been issued, my lords.
Okay.
There are 4 tax appeals, my lords.
Let notice be issued upon the respondent under registered cover and speed post, for which requisites be filed within 1
Just 2 weeks, my
2 weeks.
1 week. Manoj, whatever, my lords.
1 week. So
My lords.
appellant shall effect service of notice on the official email address of the respondent containing the attachments of the memo of appeal and its enclosures within the same period and file a supplementary affidavit to that effect within 1 week thereafter. Office to track speed post delivery.
Item 4, WPT number 215 of 2022, Mr. Batish Kumar Jha for the petitioner, Mr. Rajesh Singh, Mr. Amit Kumar for the respondent.
Yes. Who appears? Time is allowed to remove this one.
By the name of Mr. Prashant Pallab on behalf of Union of India may be recorded.
In the name of Mr. Prashant Pallab, ASGI.
For CGST, and I am appearing with.
The cause list in place of the erstwhile ASCI Mr. Rajesh Singh. In the cause list, Mr. Amit Kumar for the CGST.
Item 5, WPT number 675 of 2022, Mr. Kumar Rao for the petitioner, Mr. Rahul
As I appear for the petitioner, this matter has been listed on my mentioning, my lords. It's a matter pertaining to reassessment. Because there were 2 defects pointed out, my lords. Defect 2 I have already removed, my lords, and defect 1 may kindly be ignored because that has been wrongly pointed out, my lords. Because I am only annexing relevant part of annexure 2. My annexure statement at page 9 also says that. The defect is, my lords, that page is missing between page 31 and 32. That is the reason at page 9 I had stated, my lords, relevant portion of that said sale deed.
Why have you not annexed that page?
Milords, actually that page, Milords, some pages of that sale deed got missing, Milords. I couldn't procure that from the client, Milords. He has to again apply for a copy. That is the reason. And Milords, only thing I am trying to show from that sale deed is, Milords, that I have sold a property. I have not purchased a property as is being alleged by the revenue for reopening my assessment, Milords. So there is under a serious mistake of fact on part of revenue. Milords, and that is apparent from the reasons and the order objecting my objections, Milords, order rejecting my objections. Milords, the case of revenue is twofold, that I have purchased a property and I have sold a motor vehicle. Milords, that is palpably wrong, because I have not purchased any immovable property, Milords, rather I have sold immovable property, and Milords, those figures are reflected in my return also.
Who is the second party as per?
Milords, I'll just point that out, Milords. Second party, page 42, Milords. It's Gopal Kumar Lodha, page 42, column number 26. That is the receipt from registry. Page 42, Milords, Vendy.
Where at page 42?
Page 42, Milords, there is a column, Milords. Milords will see serial number 26, Vendy. It's just below, Milords.
26, Vendi Gopal Kumar Lodha. And you are?
Milords, I am Naveen Kumar Jaiswal, Milords. And Milords, my name is also there, Milords. If my Lord sees, from the sale deed itself, I saw page 30, Milords. I am at serial number 3. He is the SSC petitioner before my Lords. And Milords, the figures are also matching, which has been depicted in my return, Milords. I have disclosed that. Those figures are appearing in page 34, Milords. My share, what I got in from this sale, Milords, it's at page number 34. There is a table, Milords. I am at serial number 4, Milords. The amount received by me through banking channels is rupees 22,57,500. And if my Lord sees my income tax return, Milords, page 24.
Yes.
Page 24, Milords, see serial number 10, exempt income. Milords, it is 22,57,500.
This sale was an exempted income.
My Lord, it is not a capital asset, my Lord. It was agricultural land. And my Lords, I have depicted that in my computation as well. And my Lords, my computation also reflects, my Lords, the TCS deducted on the purchase of motor vehicle made by me. The TCS deduction is at page 26, my Lords, in my computation.
Anyway, defect number 2 has been removed as per by filing the relevant copies of typed copy of pages of relevant pages. Stop defect number 1 is ignored as according to learned counsel for the petitioner. The relevant pages of the sale deed are already annexed except page number 4. Stop. Next the case under the heading for admission.
Actually, I was praying for some interim protection, my Lords, because this prima facie, my Lords, this shows, my Lords, the revenue is under serious mistake of fact.
Admission in the next week.
Because actually next Tuesday is a holiday. Can it come on 2nd, then, my Lords, Wednesday?
So next week I have said.
Because actually I'm in some difficulty on 1st and 2nd. Can it be on 3rd, then, my Lords, if I may only pray? My Lords, 3rd is a Thursday.
3rd February 2022 as prayed for by learned counsel for the petitioner.
Obliged.
Much obliged.
Number 4.
Alright, item 6, first copy number 200 of 2016, along with item number 2. Mr. Sanjay Kumar in person of the appellant, Mr. Nath Tiwari for the assessment.
Complaint case has been withdrawn.
Yes, Your Lordship, we had filed an application for withdrawal and the case was listed on 11th. Both the parties appeared. Subsequently, Your Lordship, the learned judge directed the appellant to be present along with his mother, as because she was also as an accused in that case, and fixed the case on 16, in spite of stating that he will come along with his mother, Your Lordship, on 16. The appellant did not come with his mother, and now the case has been fixed in the month of March. And he has filed an application here. If Your Lordship, please just have a look to our second supplementary affidavit filed on 19/2/2020. We have mentioned the entire fact, Your Lordship. From paragraph 5 onwards.
Yes, Mr. Sanjay Kumar, क्या कहना है आपको?
मिलॉर्ड, इसमें ये कहना है कि जज साहब जो लर्नर सिस्टम में उन्होंने कहा कि ये केस नॉन कंपाउंडेबल है, इसलिए विड्रॉ संभव नहीं है, और ये मदर को लाने वाली बात ऐसी कुछ नहीं हुई थी। जो इनको आदेश दिया गया था कि ऑर्डर शीट सबमिट करें, लेकिन ऑर्डर शीट कोई लगा हुआ नहीं है और किसी तरह का ऑर्डर शीट हुआ ही नहीं था। मैंने खुद फाइल 16 तारीख को देखा था, उन्होंने विड्रॉ पिटीशन पर किसी तरह का कोई ऑर्डर पास नहीं किया। उन्होंने भरवरी मुझसे ये कहा कि ये 498 कंपाउंडेबल नहीं है, इसलिए विड्रॉ यहाँ से पॉसिबल नहीं है और ये सारा प्रोसेस ट्रायल फेज आपको करना हो। इस कारण मैंने एक CRMP फाइल किया है, जो और इसकी कॉपी उनको भी थी और सप्लीमेंट्री एफिडेविट कोर्ट में जमा किया है। उसमें मेरा इतना ही प्रेयर है कि वो CRMP में अपीयर हो जाए और एक ज्वाइंट एफिडेविट दे दें, तो हमको कोई आपत्ति नहीं है कि उनको जवाब ना दिया जाए। जज साहब से काफी रिक्वेस्ट करने के भी उन्होंने केस के विड्रॉ ऑर्डर पास नहीं किया। जो पिटीशन मैंने जो कोर्ट में दिया वो भी सप्लीमेंट्री एफिडेविट में लगा हुआ है। मदर को लाने की बात या ऐसी उन्होंने ऐसी कोई बात नहीं की थी और केस को बिफोर चार्ज एविडेंस पे ही पुश कर रहे थे।
We have categorically stated, Your Lordship, in this second supplementary affidavit that we are ready to cooperate in every manner whatever the learned court says. Now, Your Lordship, the only point for Your Lordship's kind consideration would be that two drafts to the tune of rupees 8.60 lakhs are already there with the Registrar General, and the same is going to now again expire on 26th. So I was only praying, Your Lordship, it may be released to the lady, and we have already filed an application for withdrawal before the learned Chief Judicial Magistrate. We came there on 11 as directed. Again, we came on 16. He was directed to bring his mother. He said, I will bring. And on 16th, Your Lordship, he did not come with his mother. Here also, I am ready to cooperate in all respect, Your Lordship. And I will not fail a single date, and I am ready to withdraw that case. I was only praying that the amount may be released to the lady on any condition that Your Lordship may impose upon her.
तो मिस्टर संजय कुमार, आप एक एफिडेविट फाइल कर दीजिए आज तो इस वीक में
हजूर एफिडेविट फाइल कर दिए हैं, फाइल में लगा भी हुआ है। 21 तारीख को एक सप्लीमेंट्री एफिडेविट फाइल कर दिए।
क्या लिखे हैं उसमें? वो अभी तो हम लोग के पास नहीं आया है।
लिस्ट में तो दिखा रहा है कि लगा हुआ है। फर्स्ट अपील 201 2016 में, और उसकी कॉपी भी इनको दिया है।
कल फाइल हुआ है, कल तो लगा नहीं होगा। सेम डे इंस्टीट्यूशन हो जा रहा है।
18 तारीख को हजूर फाइल हुआ है, 21 को लिस्ट हो गया है हाईकोर्ट के वेबसाइट।
तो देख लीजिए, पास ओवर करते हैं। उसमें आपने कहा है कि आपको कोई ऑब्जेक्शन नहीं है, विड्रॉ कर लें।
हजूर उसमें मैंने ये कहा है कि मैंने सीआरएमपी नंबर, सीआरएमपी फाइल किया है, जिसका अब फाइलिंग नंबर मिल गया है जो, और अगर ये ड्राफ्ट लेने के पहले एक ज्वाइंट एफिडेविट दे दें तो हमको कोई ऑब्जेक्शन नहीं है कि ड्राफ्ट लेने।
ये बताइए कि हम लोग की बात आपको नहीं सुनाई देती है क्या? आप जो बोल रहे हैं सो सब हम शांति से सुन रहे हैं। जब भी कोर्ट कुछ कह रही है तो आप बोलते रह रहे हैं। कोर्ट की बात जब उधर सुनाई दे रही है, जब कोर्ट बोलना शुरू करे तो चुप हो जाया करिए।
सॉरी।
This is something strange which I am observing. We have the patience to listen to all the parties, councils, and when we speak, they don't stop. We are functioning in a virtual mode. चलिए पास ओवर करते हैं, वो आ जाने दीजिए फिर।
Item CMP number 201 of 2018, Mr. Tejo Mistry of the petitioner.
Yes, I am appearing on behalf of appellant, Your Lordship. In this case, Your Lordship, I have filed for delay of condonation of CMP, Your Lordship. And CMP was filed for restoration of first appeal, Your Lordship, which was dismissed for default due to non-compliance of the order, Your Lordship. I have stated in para 4 and 5, Your Lordship.
Take steps. The third learned counsel for the petitioner. And there is a delay in preferring the restoration petition of 229 days, for condonation of which IA number 3915 of 2019 has been preferred. 3315 of 2019 has been preferred. Stop. Then counsel for the petitioner submits that the first appeal number 182 of 2014 was dismissed pursuant to on account of non-filing of the requisites pursuant to the order dated 24 July 2017 within time, stipulated time. Stop. He submits that delay had occasion in preferring the instant application as appellant came to know about the dismissal of the first appeal after in the second week of April 2018 from her counsel. Stop. Thereafter, the restoration petition was filed immediately, but has resulted in delay. Stop. He submitted that since the opposite parties / respondents have not yet noticed the appeal, had not yet entered appearance, the appeal may be restored for taking into account the sufficient grounds shown by the petitioner for its restoration. Stop. We have considered the submission of learned counsel for the petitioner and the reasons explained through the instant IA and the CRS and the restoration petition. It appears that at the stage of issuance of notice itself, the appeal was dismissed due to non-furnishing of requisites within time. Stop. Delay has occasion as the appellant is a lady and who came to know about the dismissal of the appeal after considerable time. Stop. Thereafter, the appeal was preferred without any waste of time. In that view of the matter, let IN delays in preferring the restoration application is condoned for the reasons recorded here and above as well. Recorded above, the first appeal number so and so is also restored to its original file. Let requisites be in the first appeal be filed within a period of 2 weeks from today. CMP stands disposed of.
3 weeks का दिया जाएगा.
3 weeks.
Number 3 to 7 of the relative, Mr. Sanjay Prasad for the appeal.
देखो नहीं
In this case, my lord, I had to file draft publication for notice upon the respondent, my lord. Draft publication was filed, my lord, but I shall have to verify. 2 weeks' time may be given, my lord.
Order was of 13th October.
But draft publication I have filed, my lord. I cannot say, my lord, where I may be given 2 weeks' time only to verify this.
Order dated 13th October 2020 has not been complied by filing requisites. Our Land Council for the appellant submits that as per his instruction, the same were filed. Stop. He seeks and is allowed 2 weeks time to fill. He seeks 2 weeks time to verify after 2 weeks.
With permission of your lordship, in serial number 4.
Yes.
Your lordship, in serial number 4, defect number 5 may be ignored.
No, we have already passed the order.
Defect number 7, 8, 9. Your lordship, but I have verified and they are correct.
We have already passed the order when the case was called out. You remove the defects.
Apologies, my lord. Due to network issue, I was logged out. And there is no defect in defect number 7, 8, and 9 as pointed out. They have been verified and they are correct, your lordship. As pointed out in defect number 7, 8, and 9.
Very well, we are passing it over for the day. The file has also gone away.
Item A, LP number 471 of 2019, Mr. Manoj Prasad for the appeal, Mr. Sandeep Thakur.
I am appearing for the appellant.
Yes.
There is an IA, probably 7 days delay, 7231 of 21. The minor delay of 7 days.
Respondents have appeared.
No, there is not appeared.
On behalf of the respondent.
For the state.
Respondent the state.
Please go to the private respondent. Issue notice on the respondent number 2 and 3 in the limitation matter and also on the main memo of appeal. On the registered cover with heading and speed post for which requisites be filed within 2 weeks. Office to track speed post delivery.
matter could have been disposed of in rules itself. Instead of going into the factual dispute, the simple thing is that both parties are objecting to the factual disputes. The law in that is section 14 subsection 2 of the Tenants Maintenance Holding Act says that the circle officer is required to make an inquiry. So only prayer would be sufficient, that if the circle officer is directed to make an inquiry and the dispute can be resolved, because this is a factual dispute, who is the successor or not, may not be able to be decided by the High Court in writ or LPA jurisdiction. So the rules and the Act provisions are very clear. Section 14.2 says that if there is an objection, the CO shall record evidences and pass order. And for that, there is a rule also that the CO shall ask for a report from the Halka Kramchari and all those, and on the basis of that, after hearing both the parties, they pass an order. खैर नोटिस हो रहा है, हुजूर का ऑर्डर है, तो हम क्या कहें. अब मेरी गलती है कि हम रूल्स मेल नहीं किए हैं.
Very well, let the opposite parties also come.
Item 11, first copy number 38 of 2021. Mr. Neelam Sinju for the appellant. Mr. Neelam G. Topo for the.
Yes.
May it please note, I have entered appearance on behalf of the respondent in this matter.
Acha.
Yes, madam. We are ready.
Who is for the appellant? Appellant's counsel. Item number 11, who is for the appellant? Mr. Akansh Kishore, are you familiar with the appellant's counsel?
Milord, I'll try to connect. Let me grant me 10 seconds.
We are passing over for one or two cases. Ask them to join.
Wait.
Their numbers, so that both the parties can be sent for mediation. Yes, next. Acha. Oh. So first over, just a minute, Mr. Lama, there is one passed over first appeal.
Popular case for item 6, first appeal number 200 of 160, along with item number 7, Mr. Sanjay Kumar Nivasan and Mr. Mahesh Tiwari for the.
Mr. Sanjay Kumar.
Lordship, item number 11.
Just a minute. We have called out a passed over matter in your absence.
Lordship.
Mr. Mahesh Tiwari. ऑर्डर वही होगा जो उनके प्रेजेंस में हो यार। 8 में जो है इसी को कोट करके नो ऑब्जेक्शन नहीं है, लोग अपील कर जाएंगे सीआरएमपी। लिखिए उनका अपीयरेंस लिख दीजिए दोनों साइड का। संजय कुमार इन पर्सन और मिस्टर महेश तिवारी। Pursuant to the order dated 2nd February 2022, parties had appeared before the learned Chief Judicial Magistrate Ranchi on 11th February 2022. Stop. Since the case is non-compoundable in nature under Section 498A of the IPC, the case was fixed for framing charge before evidence. Fixed for framing charge on 16th February 2022. Stop. Appellant has filed a supplementary affidavit on 16 February 2022. जरा खबर कर दीजिए महेश तिवारी संजय कुमार। On so and so 16 February 2022, stating that he has filed a criminal miscellaneous petition before this court for quashing the entire criminal proceeding under Section 482 of the CRPC for quashing the criminal proceeding arising out of CC number 1774 of 2007, instituted by the respondent wife. Stop. However, he has categorically stated at para 8 that he will have no objection to disbursal of the demand draft for rupees 8.60 lakhs if respondent gives affidavit and ensures that they shall fully cooperate in and file joint affidavit in disposal of the criminal miscellaneous petition preferred by the appellant. Stop. According to the appellant, his mother is 80 years old and suffering from fracture of bone, therefore could not be physically present before the learned trial court, as it is difficult for her to travel from Hazaribagh to Ranchi for travel to Ranchi. Stop. Then counsel for the respondent, Mr. Mahesh Tiwari, submits that the demand draft submitted by the appellant of rupees 8.60 lakhs is likely to expire by 26 February 2022. Stop. Therefore, an order may be passed for its disbursal to the respondent in view of the categorical undertaking of the appellant. Stop. The respondent shall fully cooperate. On her part, respondent shall fully cooperate in the disposal of the criminal miscellaneous petition. Mr. Tiwari?
Yes, Your Lordship.
Whatever I have recorded.
Yes, Your Lordship. That will be complied, Your Lordship.
Yes. Stop. Mr. संजय कुमार, आप भी जो बोले हैं वो लिखा दिए हैं। म्यूट हटाइए।
हजूर छोटा सा सबमिशन है हजूर।
हाँ।
ये चूंकि अभी सीआरएमपी का नंबर नहीं मिला है, लेकिन फाइलिंग नंबर मिला है हजूर, उसका अगर उल्लेख कर देते तो। सीआरएमपी का फाइलिंग नंबर मिला है हजूर 4607/2022।
फाइलिंग नंबर 4607/2022।
जी ऑब्लाइज।
पैरा reference may be made to the previous orders, which has taken into note the amicable settlement arrived between the parties on terms and conditions, including payment of an alimony of rupees 8,60,000 in favor of the respondent. uh, appellant does not have any objection to dispersal of the amount if the respondent cooperates in the disposal of the criminal miscellaneous petition preferred before this court, since the complaint case contains an offence which is non-compoundable in nature and could not be withdrawn. Stop. Parties have agreed to dispersal of the amount on those terms. Accordingly, respondent may approach the learned registrar general on any working day for dispersal of the demand draft in her favor of rupees 8.60 lakhs. Hearing number 805515 dated 26 November 2021. Stop. Then the Registrar General on proper identification would release the demand draft in her favor. Stop. Needless to say, the respondent should appear and cooperate in the criminal miscellaneous petition. That's all.
Your Lordship, may I just pray that this order may be uploaded and sent to the learned Registrar General at the earliest, because again on 26th or 25th it will lapse. Again the revalidation.
By tomorrow morning, it will be uploaded.
We are obliged.
Yes.
Obliged.
आइए किस चीज के लिए फाइल किए थे मिस्टर तिवारी? The relevant facts have already been mentioned in the order above. IA number so and so preferred by the respondent. Supplementary. IA. Second. मिस्टर तिवारी, आइए किस चीज के लिए फाइल किए हुए थे?
आइए वी हैव नॉट फाइल्ड योर लॉर्डशिप. आइए
नहीं फाइल.
आइए तो हम लोग के पास नहीं है.
नहीं सप्लीमेंट्री फाइल.
Supplementary.
The supplementary affidavit has also been filed by the respondent.
Item class number case, item number 11, और topic number 38 of Parliament 21. Mr. Nilabhi Sir Kumskati और अपने
Lordship, in this case, brief has already been taken away by the petitioner, Lordship, with no objection, 1 week back.
So, all the three councils are from the same office whose names are appearing?
Lordship, Ashraf, yes, Lordship, same office.
Niladri Shekhar Mukherjee, Land Council submits that the appellant has taken away the brief from their office after taking of no objection 1 week back.
Yes, Lordship.
Stop. This appellant has not entered appearance through fresh wakalatnama. Stop. Respondent has entered appearance on notice through wakalatnama. Stop. Mr. Akansh Kishore appears for the respondent. Stop. In order to grant an indulgence to the appellant to enter appearance, let the matter appear. The matter be posted on 8th March 2022.
Obliged, Lordship.
Grateful.
Item number 12, PA number 46 of 2019, Mr. Ram for the appeal.
May please, I was praying for a 2 weeks adjournment just to take instruction because though the tax effect is less, I'll have to take instruction if it is falling under any of the exceptions. So at times it happens, these matters, there are audit objections pursuant to which the subsequent assessments are done. So that an audit objection is an exception, so I'll have to check out whether it is falling under exception, So.
And counsel for the appellant, Mr. Lamba, seeks 2 weeks' time to obtain instruction as to the tax effect of the disputed amount and whether it falls within the monetary limit for preferring the appeal before the High Court. Before this court. For the respondent, Mr. Suresh Poddar. Will the matter be listed in the week of 7th March?
Much obliged,
Item 13, PA number 54 of 2019, Mr. Ram for the appeal.
Notices will have to be issued, in this matter,
No other analogous appeal?
No,
Issue notice on the respondent under registered cover with AD and speed post for which requisites be filed within 1 week. This one also,
This one also, Mr. Lamba, will have to seek instruction and file affidavit.
Fine, I'll take instruction,
Penalty, as per the circular, penalty will amount to tax.
Yes,
The total penalty for 3 years is very less. You see the exception ground of circular file affidavit.
So, in that event, then let the notices be deferred, let the matter come after 2 weeks, I'll take instructions,
reference is made to the order of the Commissioner IT CIT Appeal 3 Patna at Annexure 2. Stop. Learn counsel for the appellant, Mr. Lamba, seeks 2 weeks' time to take instruction as to the tax effect of the disputed amount, whether it falls within the monetary limit for preferring this appeal. Stop. List the case in the week of 7th March.
Much obliged.
Item 15, PA number 57 of 2019, Mr. Ram for the appeal, Mr. Mahendra Kumar for the respondent.
In this matter, the issue pertains to section 234B, whether interest has to be charged on the returned income or on assessed income,
In this case, there is exception.
I think, it is covered by the exception of audit objection,
Yes.
Your Honor, I am appearing on this case on behalf of the respondent, Your Honor. This was a normal scrutiny assessment, Your Honor. There was no audit objection to this case, Your Honor.
If my learned friend is stating so, then I'll take specific instructions and bring those audit objections on record,
वो लगता है एग्जाम हो गया।
I'll bring that fact, my lords, before my lords, whether it is as per the audit objection.
Counsel for the appellant, Mr. Lamba, prays for 2 weeks' time to obtain instruction as to the tax effect of the disputed amount and whether the instant case falls under any of the exceptions under which appeal can be preferred despite the monetary limit. As prayed for, matter is adjourned for 2 weeks.
Much obliged, my lord.
Yeah, 2021, 22 से जरा first appeal call करें.
Item 20, first appeal number 33 of 2021, Mr. Amish Sekhar of the appellant.
Issue notice on the respondent. Ex parte judgment. Under registered cover with AD, speed post and ordinary process, for which requisites be filed within 2 weeks. Order 9/13 के खिलाफ. Mr. Shekhar, you have heard?
Yes, my lords.
Very well.
Item 21, first appeal number 45 of 2021, Mr. Nilesh Kumar of the appellant.
Lordship, I am appearing on behalf of appellant.
You are Ms. Alka Kumari. Grandmother and mother के बीच की लड़ाई है.
Mother and grandmother.
Grandmother's suit has been dismissed.
Your Lordship, in the earlier suit in which grandmother was allowed the custody of the
Grandmother
minor
was
girl. Yes, Lordship. In this present first appeal has been filed by the mother.
Why in the presence of mother the grandmother was character?
Only on the basis that the mother was convicted in the murder case. The custody was given to grandmother.
Issue notice on the respondent on the registered cover with AD, speed post and ordinary process, for which requisites be filed within 1 week.
Apply or not?
1 week में कर दीजिएगा ना?
Your Lordship, 2 or rather 4 weeks time may be given.
4 weeks. इतना छोटा सा petition. Speed post and ordinary process कर दीजिए registered cover. Office to track speed post delivery.
Item 22, first appeal number 43 of 2021, Mr. Rajiv Wilson of the appellant.
Yes, my lord, appeal, my lord, arises out of the order dated whereby the order 9/13 petition has been dismissed by the
Issue notice under registered cover with 80 speed post and ordinary process, for which requisites be filed within 2 weeks. Is to track speed post delivery. इसमें तो काउंटर चाहिए होगा डीजल वगैरह तो थोड़ी करते हैं इसमें
Item 23, WPC number 464 of 2021, Mr. Sunil Govila for the petitioner.
Yes, Mr. Garodia, Mr. Amit, Mr. Pati.
Minor.
Mr. Garodia. Who is appearing in item 23?
23, I am appearing for the respondent, my lord. Mr. Garodia is for the petitioner.
Counter is required.
On a Tata Steel long product. WPT 464 of 2021, my lord.
Right.
Well, counter is filed. The pleadings are complete, my lord, as per my record. Yes,
Oh.
rejoinder is also there, my lord.
Then we'll take up after some time. ये 16 कॉल कर लेंगे.
Item 16, possible case, WPS number 7311 of 2019, Mr. Satish Kumar Gaur for the petitioner.
मेरा नहीं.
Who is appearing in item 16? ये वही है जो WPS का.
Because I appear for sale Milad in this matter.
So that WPS was effective. We granted 1 week time perhaps to Mr.
Because that is CMP number 149 of 2021 Milots. Now defects have been removed Milots and supplementary affidavit was to be filed Milots for removing of a defect. That has been done Milots and it has been mentioned also before the honorable bench Milots.
So that petition has not yet been restored.
Yes, Milots, that has not CMP that has not been heard Milots, the CMP for restoration.
वो CMP जो एक था श्रेष्ठ गौतम जी का वो आज
CMP number 149 of 2021.
एक्चुअली वो टाइड अप बेंच है, टाइड अप में नहीं है. हाँ 21 149 of 21. हाँ उसको आज लग जाने से defect in CMP has been removed, Mr.
Yes, Milots, that is my instruction. They have been moved.
आज लिस्ट हो सकता है क्या? नोटिफाइड. तो आप एक स्लिप बोलिए मिस्टर गौतम को भेज देने के लिए ताकि वो नोटिफाई हो जाए.
ठीक है.
इसमें लिख दीजिए मिस्टर पीयूष चित्रेश. देखिए इसमें आप मिस्टर चित्रेश यू आर फॉर सेल ना respondent. Mr. Piyush Chitresh, then Council for Respondent Sale submits that the WPS number 3515 of 2019 has not yet been restored, though surviving defects in CMP number 149 of 2021 has been removed pursuant to the order passed by the coordinate bench on the previous day. आपको पता है ना उसमें जो डिफेक्ट था रिमूव हो गया है ना?
Yes, Milord. I've spoken to Mr. Gautam and he has instructed me.
As such, therefore, matter may be adjourned for one more occasion so that both the writ petitions can be heard together. As prayed for, list the case on 9th March 2022. ये 25 एक मिनट कॉल के लिए इसमें लगता है काउंटर चेंज हो गया इंटरेस्ट वाला है भाई
May it please your lordships. Lordship, this is the same matter which your lordships heard last on 17th of February. Mr. Kurmi was addressing the court. Because I have sent some judgments yesterday just to add on to what he had said. And one particular rule and section which was not placed by Mr. Kurmi, I would have to do just that and nothing more, Lords.
But response will be required.
As a matter of fact,
it's coming for the
point of
first.
law, the facts are not disputed. So I leave it up to the court, of course, but I think if I am given 15 minutes, so I don't think any response as such would be required on a point of law. Point of law, counter affidavit has already been filed. The only thing is that I can add on to what Mr. Kurmi had said. There are a couple of judgments which I have sent, which would be very helpful to the court while deciding the matter.
I will seek time to file the reply, my lord. Count is coming for the first time. The counter is not filed.
Give you time because.
But if the court permits me, I can just place the judgment, so it can be helpful to the court in delivering the judgment in the earlier matter. Or your lordship can, and it's been confirmed by the Supreme Court, the Delhi High Court judgment. I've sent the judgment of the Supreme Court as well, and there's one Supreme Court. There's one Supreme Court judgment also which I have sent.
So the Delhi High Court judgment affirmed by Supreme Court is to the effect that if the tax is already deposited with the exchequer, then there is no delay.
That's right.
In deposit of tax and delay in filing return
doesn't affect the liability regarding interest. If I paid
affidavit.
Can it be before 7th? Because I would like to address the court before the judgment is delivered, if possible, of course.
One I will not be able to file
one particular rule which was not placed by Mr. Kurmi, can I just place that rule? Then thereafter you can.
Kindly place which rule are you relying?
Yes. Kindly come to page 17. Rule 87. Page 17 at the bottom. Rule 87. This perhaps was. This perhaps. Pardon?
This is also state tax or central?
Central.
Okay. So rule 87.
Page 17, Rule 87, electronic cash ledger. Any person or a person on his behalf shall generate a challan in form GS2 PMT6 on the common portal and enter the details of the amount to be deposited by him towards tax, interest, penalty, fees or any other amount. Now at the next page, sub-rule 6. On successful credit of the amount to the concerned government account. This is important. The moment I deposit cash, it is credited to the concerned government account. Maintained in the authorized bank, a challan identification number shall be generated by the collecting bank and the same shall be indicated in the challan. On receipt of the challan identification number from the collecting bank, the said amount shall be credited to the electronic cash ledger of the person on whose behalf the deposit has been made, and the common portal shall make available a receipt to this effect. So what I wanted to convey to this court, that the moment the amount is deposited by me and it is credited in the cash ledger, the amount goes to the government. The amount goes to the government because it is just a fiction. It's just a fiction, a deemed fiction, that when the amount is lost, when the GSTR 3B is filed, then on that day the amount is credited to the government. This is just a fiction. Otherwise, because even the ITC which I have claimed, that also is credited to the account of the government on the date this Form 3B is filed. And if we see, once again, your lordships of course have gone through that section 50, that which I've quoted at page 23. The word or part thereof would be very important at page 23, section 50. It's very specific. Page 23, may I place that? Section 50.
Just a minute.
Yes. Every person who...
Clause 3 or...
No, I'm 51. Section 51.
51.
Yes. Every person who is liable to pay tax in accordance with the provisions of this Act or the rules made thereunder, but fails to pay the tax or any part thereof. So it's divided into two parts, that either you paid the full tax or a part tax. So this would definitely mean that interest, if any, would be only on the part thereof, which I pay later after 20th. So this makes a very clear distinction. The words or any part thereof is very, very clear. And even the proviso to this, it says, provided that the interest on tax payable in respect of supplies made during a tax period and declared in the return for the said period furnished after the due date in accordance with the provisions of section 39, except where such return is furnished after commencement of any proceedings under 73 or 74, shall be payable on that portion of the tax. Now, I would relate these words, that portion, to any part thereof. I would relate it to that. I would relate these words in the proviso, that portion, to any part thereof in subsection 1 of section 50. So therefore, it's absolutely clear.
Right.
And then there was one judgment of the Honorable Supreme Court also, which I have seen is just a 3-4 page judgment, paragraph 15 and 16, because in my case, it's a case of refund. I have paid the entire amount because if I would have not paid, they would have stopped my EVA bills. So I had no option but to make the entire payment. Whatever delay is there, I am liable to pay. So for my case is concerned, the amount which I paid belatedly was 2 crore 32 lakhs, and I was liable to pay interest because for 2 years, 1 day's delay, for 1 year, 5 days delay, like that. So the amount, and as a matter of fact, for a moment, I will take your lordships to page 11, the details of my transactions. I've made a chart of that.
See the counter affidavit come.
Very well, very well. So these are the things which specifically I wanted to point out, and especially that Supreme Court judgment, because I don't know whether in Mr. Kurmi's case any refund was there. In my case, refund is there, and the Supreme Court has said in paragraph 16 in the judgment, that is 1987 supplementary SCC 442, that the refund has to be made. If I may place paragraph 16, last 4 lines. Paragraph 16 at page 452.
Yes.
Then let me place 15 also, 15 and 16. Before we part with these appeals, we think we should clarify one situation, namely, whether advance tax duly paid covers the entire amount of tax assessed, there is no question of charging the registered firm with interest, even though the return is filed by it beyond the time allowed. Regard being had to the fact that payment of interest is only compensatory in nature, as the entire amount of tax is paid by way of advance tax, the question of payment of any compensation does not arise. In CA number such as
You are reading which paragraph of which?
paragraph 15, Lordship, paragraph 15 I just placed. I'll place it again, which is at page 51.
Of Delhi High Court judgment.
No. That's Supreme Court judgment. Ganesh Das Shriram. 1987.
We don't have.
Oh, I've sent it yesterday. I've sent it.
Ganesh Das. Yes, we have got the.
Yes. Paragraph 15, Lordships. At page 451, paragraph 15. May I place it? Before we part with these appeals, we think we should clarify one situation, namely whether the advance tax duly paid covers the entire amount of tax assessed. Where the advance tax duly paid covers the entire amount of tax assessed, there is no question of charging the registered firm with interest, even though the return is filed by it beyond the time allowed. Regard being had to the fact that payment of interest is only compensatory in nature, as the entire amount of tax is paid by way of advance tax, the question of payment of any compensation does not arise. Then 16 notes, last 5-6 lines I am reading. As has been observed earlier, just below the middle, as has been observed earlier, when the amount of tax has already been paid in the shape of advance tax, the question of payment of compensation by way of interest does not arise, and the income tax officer was not therefore justified in charging interest. The assessee is therefore entitled to get refund of the amount paid by way of interest for the said assessment year. The income tax officer is directed to refund to the assessee the amount paid on account of interest. So in our case also, we had to, under threat of coercion and under the threat of stopping of EVA bills, we had no option but to deposit the amount. So ultimately, if we succeed, then we are entitled to refund of this.
Yes. Mr. MS Mittal, Senior Advocate for the petitioner, Senior Counsel for the petitioner, Mr. P.S. Patli for the respondent, Senior Counsel for the respondent, Mr. Pati. Praise for is allowed. How much time, Mr. Pati?
4 weeks, madam.
4 weeks to file counter affidavit. Sentence and the senior counsel for the petitioner submits that the legal issue involved in the present petition is whether
any interest is payable on the amount already paid, on the amount of tax already paid before the due date.
Tax paid through electronic cash ledger prior to the due date of filing of GSTR 3B.
Yes, Lordships.
And counsel for the respondent is allowed 4 weeks time to file counter affidavit, 1 week thereafter to the petitioner to file reply, which take 5 weeks.
So if a date could be given,
May I please the court, Lordship?
Just a minute. This case is still going on.
Month of April 2022.
Any date, Lordships, if possible?
Date at this length of time may not be proper. We have indicated in the April it will be listed.
Very well, very well. After the counter is filed, I'll make a mention. After counter rejoined as well, I'll make a mention. Or if the time period is over and no counter is filed, then I'll make a mention.
Right.
May I please the court, Lordship? Lordship, name of Mr. Prashant Pallav SJI recorded on behalf of Union of India may be recorded, Lordship.
In which case?
20 in serial number 25, Lordship.
Present ASGI appear in the cause list in place of the erstwhile ASGI. Henceforth.
Obliged, Lordship.
Lordship, serial number 23, my lord. I apologize, my lord. On that time, I could not appear, my lord, due to some technical error from our end, my lord. Lord, in this case, my lord, pleadings are completed, my lord, and we have also given a written statement judgment on comparison, my lord. May I, although, my lord, the list is going to be, may I pray that it may be taken up on second half, my lord, if Lordship permit. My senior is on legs at court number 1, my lord.
Not today, if it is passed over for the day, it will come in the next week itself.
My lord, then it may be taken up tomorrow, my lord. It's a cover matter, therefore I am praying, my lord, that it may be taken up on tomorrow.
एक मिनट टेक को रखते हैं next Thursday.
My lord, may I pray for tomorrow, my lord, subject to lordship kind convenience.
Like tomorrow we can't accommodate. Tomorrow we have the list already complete, and next week Thursday we can adjust.
Subject to lordship kind convenience, Monday, my lord, if possible, my lord, I am just requesting the court.
No, I have seen
We have finished our list.
our diary. We have produced. We have so many matters on Monday. Otherwise, in the next week, in the week of 7th March, we can post it on any day.
Then next Thursday, my lord.
Next Thursday, we can give you time.
Yes, my lord.
Next Thursday, 3rd March 2022.
Much obliged, my lord.
Item 24, WPT number 786 of 2021, Ms. Amrita Sinha, forward petitioner.
May I please, Your Lordship?
Yes.
In this matter, Your Lordship, we have prayed for setting aside the appellate order as well as the assessment order passed under section 62 of the JGST Act, and also allowed the petitioner to avail and utilize its input tax credit, which has been blocked by the department. Now, the core issue of this particular matter is, Your Lordship, whether an assessment under section 62 is a valid assessment in the case of a non-filer of a return. Now, the short fact of the matter, if my list of dates may kindly be seen, Your Lordship, a very short fact of the matter, just my compilation I have given, Your Lordship, wherein list of dates.
मेल से मिला हुआ है. निकलवा बन ही नहीं रहा है। So, according to you, one issue is whether assessment under section 62 can be done without prior notice under section 46.
Yes, Your Lordship. This is the first and the foremost issue.
Second is that no notice was issued before passing of the order on 2nd August 2018.
Yeah, this particular order was, although they are claiming that they have sent it by mail, but we have not received any such mail. And for the very first time on 1st of October, we came to know when the DRC 07 was issued. And in the DRC 07 also if Your Lordship look into the date mentioned in the DRC 07 is some other date. That is 28th of September 2018. And within 30 days, we have filed our return. And moreover, the assessment order under section 62 is a cryptic order. Nothing is there, not a single word is there, only the figure is there mentioned in the 62 order. So at the very primer is the nullity and it is a cryptic order, Your Lordship. And other issues are also there, like charging of interest under section 50, charging of penalty under section 73, subsection 9. These are the other issues, Your Lordship. But the first and the foremost is whether without serving of notice under section 46, can assessment be done under section 62 of the JGST Act?
Mr. Pati is appearing.
Yes, my lord. Lord, I took instruction from my clients, my lord, that notice we could not locate, my lord, prior to the order under section. Those were my facts which are there. I must fairly admit that my clients could not. For that purpose, I had taken time on that day. They could not trace it out.
Notice under section 46.
Yes, as required under Rule 68. For non-filers who don't file the return.
So page 63 itself speaks of that. Page 63 and 64.
Then in that case the whole order fails.
As per me, Your Lordship, yes. There is also a judgment of the Supreme Court which I am relying upon.
Which page were you referring to? Page 60?
Page 63, Your Lordship. That is the impugn order.
Oh, 2nd August.
Yes, Your Lordship, 2nd August. The very first line says that the notice referred above, however, notice referred above nil, dated nil. There is no notice at all. Was issued to you under section 46. The very first line it states so.
There is a statement in the writ petition.
Writ petition, Your Lordship, in the writ petition, Your Lordship. That no notice whatsoever was issued, yes.
16,
even in the and even in the rejoinder, we have specifically stated the guideline SOP, wherein it also says that, and the section also says that it is a mandatory procedure which has to be complied with.
There is no categorical reply.
They have stated no reply at all.
Was given, but the document to that effect is not on record, my lord. Any document supporting that statement?
Vague reply.
Vague reply, they are stating nothing has been stated. In the rejoinder also I have categorically mentioned about this particular thing. At page number 5, para 8, Your Lordship. May I just read para 8 of my rejoinder?
Yes.
It says, Your Lordship, that it is further stated and submitted that the respondent department has not even adhered to the standard operating procedure SOP to be followed in the case of non-filers of return. The Government of India, Ministry of Finance, Department of Revenue, Central Board of Indirect Tax and Custom, White Circular number so and so dated 24/12/2019, has issued clarification and guideline to ensure uniformity in the implementation of law in terms of Section 62 of the Act. The said guideline has not been followed by the respondent department before initiating proceeding under Section 62 of the Act. Neither any notice under Section 46, it will be, of the Act has been issued and served upon the petitioner. For ready reference, the guideline issued by the Government of India is quoted herein below. The guideline, the important is relevant is, Your Lordship, page 7, the third point.
Yes.
5 days after the due date of furnishing the return, a notice in form GSTR 3A under Section 46 of the CGST Act, read with Rule 68 of the CGST rules, shall be, the word uses shall be issued electronically to such registered person who fails to furnish return under Section 39, requiring him to furnish such return within 15 days. Even Section 46 and Section 62 also says that a notice has to be issued. The word used in Section 46 is also shall, and even under Section 62 it is it says that even after the service of notice under Section 46, if the return is not filed, then the assessing officer or the proper officer may proceed to. Not even compulsion, but may proceed to. However, the service of notice under Section 46 is a compulsion. And it's a mandatory provision, Your Lordship. The section itself says that, and that in Section 62 specifically, Section 46 has been mentioned therein. So when a specific section is mentioned, the Honorable Supreme Court has said that that has to be complied with. Their reply is there, Your Lordship. They have just stated in a simple line that disputed and denied in a vague, very vague manner. And may I just show, Your Lordship, from my written argument, I have stated the section also and the other relevant section also. I may be permitted to show Section 62 if.
The extended date for filing the return was 31st of December 2018.
Even beyond that, it was extended, Your Lordship. Time and again, it kept on extending.
Yes, Mr. Pati.
No, the 3A notice, my lord, is not there, my lord. It has been passed. We say that it was noticed, but that document to support that contention is not there. The order was passed. As per records, that 3A notice is not there. That ought to have been issued to him.
So any categorical statement that it was issued?
Not very specific, my lord, and yes, not specifically, not to that extent.
No, Your Lordship, it is not no categorical statement made therein.
Because my officers, my lord, they have checked it on the system and the file as well. So the officer who passed this order is not there right now, but the successor in office, he told me today also morning that I am not able to find it. Prior to GST 3 are there, but subsequent to this orders, not prior to this order. But that is not in writing, my lord. Telephonically he informed me after checking the file and the records. But one pertinent thing, appeal, my lord, the appellate order reading shows that they were mainly arguing the case on the ground that the return was filed within the prescribed period of receipt of the assessment order. So it has to be as per the subsection 2 of section 62, the order will go. But we have filed proof of the emails showing that the order was duly sent through email. So non-service of the order is not correct, my lord. That we have categorically denied. And brought evidence to that effect also by filing the email.
The appellate authority has not quoted the full section 62. 1.
Yes, Your
Has
Lordship.
quoted section 62 to subsection 2 because that was the case made out and argued before him. That we have filed the return.
Even the assessment order will go, Your Lordship, itself.
The assessment order itself says in the first line that notice referred to above was issued to you under section 46 of the Act.
Yes, Your Lordship. And the notice referred above, when we see above, the notice reference number nil, dated nil. So this is basically, Your Lordship, it is a particular format. If in the book, Your Lordship may kindly see, ASMT is in this particular format. So the assessing officer has not applied his brain, he has just merely copied the format and he has just filled the table and he has passed the order. This is the exact line by line the format is there of ASMT 10, which can be seen, Your Lordship, because it can be seen introduction, no introduction of the cases, submission if any, no submission, discussion and finding, there is no discussion and finding, conclusion, no conclusion at all, amount assessed, only the amount has been feeded. So this order itself is a cryptic order, Your Lordship. Merely SMT 13 has been put into and nothing else. Not a single word has been uttered in this.
Yes, Mr. Pati, there are so many lacunae in this order and proceeding. Time and again, this is
That
happening.
time GST had just come into force, my lord. At that time,
No, the SSCs are suffering because of that, and the court is being burdened every day.
Similar type of problem.
This
now these days, my lord, now they are not passing, my lord, orders of this kind.
They are in my one other matter also. Similar nature of things has been done. I'm in a process of filing that also, Your Lordship. It's a recent order itself.
What is the purpose behind giving a notice under section 46?
The purpose behind is that the non-filer can file the return and the proper assessment can be done. Even section 62 subsection 2 also says that even after passing of the assessment order, if within 30 days the return is filed, then the assessment order will be deemed as withdrawn. So the purpose behind section 46 is to bring to the notice that look, you have not filed the return, kindly file the return. Return filing is the main purpose of section 62 and section 46 notice. Similar provision was there in the income tax also for the assessment of block assessment. The notice under section 43 section itself, notice under section 143(2) was required to be issued. The department in that submitted that it is merely a procedure irregularity, hence it should go. But the Honorable Supreme Court said that it is not a procedural irregularity, but it is a mandatory thing which have to be complied before passing a block assessment.
And now, in fact, that section 148A
Yes.
has
that is a yes, Your Lordship. That
fee change. Even for issuing a
even the
notice,
new section says that
inquiry has to be done, notice has to be given, and then only a notice under section 147 has to be.
Yes, Your Lordship. Even the new Act of Income Tax 148A speaks of that. So notice if it is mandatory thing. And the language of section is very, very clear, Your Lordship. It's crystal clear, the language is.
What if we set aside the order on discount? Is there any necessity now to initiate a fresh proceeding by issuing notice because the return has already been filed?
Yes, Your Lordship. Return has been filed. That return has been accepted.
Lordship may observe the purpose of the notice does not survive. That has become redundant because now the petitioner has knowledge and has filed its return. So that is on record. So we'll proceed to pass order on that based on those returns.
And the filing GSTR 3B continue to be extended till February 2020 or March 2020.
Sorry, Your Lordship, your voice was just breaking.
The time limit for filing the return was extended finally up to what date?
It was extended up to 31st/8/2021. With a late fee, of course.
Have you enclosed?
That I have not enclosed, but on the earlier occasion, once I mailed it, Your Lordship, on the very initial stages when the matter was once heard, then I have mailed it. I don't remember exact date, but that notification, I can give the date, Your Lordship, of the notification.
And this, which you have stated in your rejoinder, that it was extended at that point of time till 31st December 2018, have you then enclosed that notification?
No.
No, Your Lordship,
So
I have
that is
not
not
annexed
enclosed.
the notification. I have not annexed that notification.
No, but as a matter of fact, when the time of return, filing of return was getting over, was that notification extending the time limit already there?
At that particular time, it was not there. It came later on, Your Lordship. Time and again, it kept on extending. The very first notice came in 15th September 2017. Then it was extended on 20th of January 2018. Then again on 31st December 2018. There are many notifications, Your Lordship, number of notifications are there wherein it was extended time and again with the late fee and penalty. If any. Return का timing.
Should be scrutinized.
In para, sorry, Your Lordship.
Because of the demand of rupees 3 crore 30 lakhs, your ITC of 2.88 crores lying in the credit ledger has been blocked.
Yes, Your Lordship.
So if the assessment order goes for this reason, then the blocking also goes.
Yes, Your Lordship. That have to go. And specific prayer is also made. Prayer C is there, Your Lordship, for that purpose.
And the returns that you have filed with late fee, they have to be scrutinized and that they can proceed to pass necessary orders.
Yes, Your Lordship.
If they have proper valid returns or not.
Yes, Your Lordship. So far as my knowledge is concerned, Your Lordship, my returns has already been accepted by the department. It has not been denied therein. And during that period, I didn't enter because it was a new company. However, thereafter, I am also regularly paying my taxes and filing my returns. So things are regularized before that, Your Lordship, after that particular period.
Mr. Pati?
For later period, they have been noticed, my lord. 3A is there. Perhaps they have again not filed the return. But those pleadings are not here, my lord.
No, we are not concerned about the later
yes,
period.
Subsequent period pleadings are not there.
Confined to the materials related to this period, what we observed a while ago, this has to be the fallout as per you also?
Yes, my lord.
Can I just also submit, Your Lordship, that for availment of ITC which was lying in my electronic ledger, section 16 subsection 4 specific was there that if you have not availed that, you can avail it by 20th of October to this next year, Your Lordship. So even before that availment, I was entitled to avail. Even before that, Your Lordship, without any prior intimation, they have blocked it. So I could not even avail that also because it was availed beforehand, even in spite of that fact that the time period was there for availment.
So once it is unblocked, then you can use it now, or is there any rider to that also?
So I may be permitted to use that also, Your Lordship. I don't think so there will be any rider, but I still have a doubt, Your Lordship, because they can say that it was still only 20th of October 2018.
Yes,
But then I guess it won't
those
be.
situation has not arisen as of now.
I guess it will be. I will be able to avail that, my Your Lordship. Even I am of the view that I will be able to avail.
Our learned counsel for the parties. Petitioner, a company engaged in construction work and registered under the GST Act. Petitioner company engaged in construction work got itself registered under the GST Act in December 2017. According to it, during the period under consideration, December 2017 to March 2018, it had not undertaken any work. However, a project loan was taken by it in December 2017 for business purposes, for which the Diwan Housing Finance Corporation Limited DHFL charged rupees 16 crores as loan processing fee, along with GST at the rate of 18% being rupees 2.88 crores, and issued two invoices dated 30th December 2017 and 28th March 2018. Annexure 2 series. Petitioner furnished the details of inward supply of services received under section in GSTR 2A in terms of section 38(2) of the JGST Act, Jharkhand Goods and Services Tax Act 2017, read with Rule 60 of the JGST Rules 2017, showing taxable value of inward supply of rupees 16 crores and claims to have paid tax to the tune of rupees, input tax to the tune of rupees 2.88 crores. Stuff. According to the petitioner, since no work was being undertaken in the month of December 2017, nor any sale or purchase was done, nor any payment received or any supply of goods or services done, petitioner did not file its return for the aforesaid period due to ignorance of law within the time prescribed under section 39 of the JGST Act 2017. Stop. According to the petitioner, it received a summary of order under DRC 07 dated 1st October 2018, uploaded in its portal, which indicated that an order was passed on 28 September 2018 under section 62. Assessment order was passed on 28 September 2018 under section 62 of the JGST Act for the period July 2017 to March 2018, raising a total demand of rupees 3 crore 30 lakh 76,800, wherein the ITC to the tune of rupees 2.88 crore was denied and an equal amount was levied as tax, and further an interest and penalty was charged by the annexure, within bracket annexure 3. According to the petitioner has made categorical statements that though the DRC 07 summary order mentioned of an order of 28th September 2018, but no such order was uploaded in its electronic portal. Petitioner applied for the certified copy of the entire order sheet and also filed its GSTR-1 and GSTR-3B for the period December 2017 on 17th October 2018 within 30 days from the receipt of DRC 07 as per section 62 of the JGST Act, showing nil return and claiming ITC to the tune of Rs 2.88 crores against tax paid at the rate of 18% on the project loan from DHFL. Stop. Petitioner further filed its return being GSTR 01 and GSTR 3B showing nil returns for the month of January, February and March 2018 on 26th October 2018. All those returns were accompanied with interest and late fee as per Annex 4 series. Being aggrieved by the petitioner also made a request to the Commercial Tax Officer, Ranchi South Circle, through letter dated 25th October 2018, to revise the order in terms of the return filed by it. It claimed that since no outward supply had been made, so they were not liable to pay any GST. Our petitioner was surprised to receive the certified copy of the entire proceeding under section 62 of the Act, from which he came to know that an assessment order dated 2nd August 2018 has been passed. Stop. The respondents claimed that the authorities verbally claimed that the order had been mailed to them. Stop. However, no such mail containing the assessment order had been received by the petitioner. Stop. No such notice or assessment order was ever issued and served upon the petitioner. Stop. Being aggrieved, petitioner preferred an appeal under section 107 of the JGST Act after making payment of rupees 28,80,000 being 10% of the disputed amount as per section 107 subsection 6 clause B, annexure 8. However, according to the petitioner, the appellate authority respondent number 2 the appellate authority, without considering, appreciating the facts on record, dismissed the appeal on 25th January 2020, bearing memo number 1166. Observing that the petitioner had filed the GST R3B return beyond the period of 30 days, as mentioned in section 62, subsection 2 of the Act. Stop. A demand notice in form GST APL-04 to the tune of rupees 3,30,76,800 was issued. Annexation 9 and 10. Stop. The department had blocked the ITC of the petitioner being to the tune of rupees 2.88 crores and adjusted the same against the disputed tax liability in question. Petitioner, being aggrieved thereby, has approached this court in the present writ petition inter alia, praying for A, setting aside of the appellate order dated 25th January 2020 within bracket annexation 9 passed by the Joint Commissioner of State Taxes within bracket appeal, Ranchi Division, Ranchi. B, for quashing of the assessment order dated 2nd August 2018 passed under section 62 of the JGST Act by the Deputy Commissioner of State Tax South Circle, Ranchi, and DRC 07, summary of the order dated 1st October 2018, Annexure 3. Stop. Petitioner has also prayed that it may be allowed to avail / utilize the ITC amounting to rupees 2.88 crores, which has been blocked and adjusted against the disputed demand. Stop. Based on these facts, Learned Counsel for the petitioner has made the following submissions. 1. According to the petitioner, no notice under section 46 of the JGST Act was served before passing of the assessment order under section 62 of the Act, though it's a mandatory condition. Stop. It is submitted that section 62 itself provides that only after service of a notice under section 46, the proper officer may proceed to assess the tax liability on best judgment, taking into account all relevant materials available or which he has gathered. Stop. According to the petitioner, the assessment order can be passed within a period of 5 years from the date specified under section 44 for furnishing of the annual return for the financial year to which the tax is not paid. Stop. It is submitted that section 62(2) further provides that if a valid return has been furnished by the registered person within 30 days of the service of the assessment order under subsection 1, the said assessment order shall be deemed to have been withdrawn, but the liability for payment of interest under subsection 1 of section 50 or for payment of late fee under section 47 shall continue. Stop. It is submitted that compliance of notice under section 46 being a mandatory condition, no assessment under section 62 could be made without issuing notice. Stop. The non-issuance of notice is not a mere procedural irregularity which can be cured. Stop. In this regard, reliance is placed upon the decision of the Apex Court in the case of so-and-so 2010 3 SCC 259 in a case arising out of the reassessment proceedings under section 143 of the Income Tax Act.
It was block assessment, not reassessment.
Block assessment. Block assessment. Stop. petitioner contends that no assessment order dated 2nd August 2018 had been served upon the petitioner through mail as per categorical statement at para 17 of the writ petition. For the first time on 1st October 2018, on receipt of the DRC 07 in the electronic portal, petitioner came to know about such proceedings and immediately filed its return within 30 days thereof. 30 days of receipt of the summary of the order. Stop. As such, the assessment order ought to have been withdrawn. Stop. 3. Then counsel for the petitioner has taken us to the assessment order at Annexure 6 and tried to demonstrate that it's a non-reasoned order passed in a format without any application of mind. In a format of ASMT 13 without application of mind. Stop. No reason at all have been stated as to how non-filing of the return attracts tax liability under the Act, as admittedly no sale and purchase had been done during the period from December 2017 to March 2018. Stop. Merely on the basis of GSTR 2A capital showing ITC amounting to rupees 2.88 crore lying in the electronic credit ledger of the petitioner, respondent department has ascertained the tax of an equivalent amount. Stop. No materials have been recorded, no findings have been recorded to show that petitioner has committed tax, was involved in tax evasion. Stop. 4, Roman 4. Then counsel for the petitioner submits that in terms of section 50 of the Act, interest is to be levied upon a person who is liable to pay tax but fails to pay tax or any part thereof within the due time prescribed for filing GSTR 3B. Prescribed. Within the period prescribed. Stop. Without arriving at a specific finding as to any tax due for the said period, interest has been charged upon it. Stop. Roman 5. Then counsel for the petitioner has also submitted that penalty under section 73(9) amounting to rupees 3,88,800 ought not to have been levied. Since there was no liability for payment of any tax, nor any question of tax not paid or short paid for the period in question, neither that the petitioner had wrongly availed or utilized any ITC. Stop. The ITC was merely lying in the electronic credit ledger, which has been blocked by the respondent. Stop. Roman 6. It is contended that as per section 16(4) of the Act, a registered person is entitled to take ITC till 20th October of the following financial year. Stop. However, due to, that is 20th October 2018. However, due to the action of the respondent department, the ITC has been blocked even before expiry of the said period. Stop. Petitioner is unable to utilize or the ITC for discharge of its tax liability for subsequent periods. In some learned counsel for the petitioner in summary has summarized her submissions and submitted that and prayed that the impugn assessment order as well as the summary of the order, assessment order at an dated so and so, annexure 6, summary of the order DRC 07 dated so and so, annexure
Annexure 3, Your Lordship.
3,
DRC 7,
and
Annexure
the
3.
appellate order dated 25th January 2020, annexure 9, be set aside. Stop. A petitioner may also be allowed to avail the input tax credit amounting to rupees 2.88 crores as shown in its GSTR 2A. Stop. Respondents have filed a counter affidavit. Taking a plea that the writ petition is not maintainable in the light of alternative remedy. Stop. It is then counsel for the respondent, Mr. P.S. Pati, has further submitted that the DRC 07 was issued only due to non-filing of returns by the petitioner on the basis of the assessment order passed on best judgment assessment under section 62 of the Act. Petitioner did not file its return within 30 days of the passing of the assessment order in terms of section 62(2), which could have led to withdrawal of the assessment order. Stop. That petitioner had filed its return in the month of October 2018, whereas ASMT 13 was emailed to the petitioner on 2nd August 2018 itself. Stop. No specific denial has been made of the categorical statement made by the petitioner with proof with supporting document that notice under section 46 was served upon the petitioner before carrying out the assessment under section 62 of the Act. Stop. Petitioner in his rejoinder affidavit has referred to the standard operating procedure framed by the Central Board of Indirect Taxes and Customs by Circular number 129/48/2019-GST dated 24th October 2019, December 2019, for ensuring uniformity in the implementation of law in terms of section 62 of the Act. The relevant referring to the extracts quoted thereunder, it has been submitted by learned counsel for the petitioner that service of notice under section 46 of the CGST Act has been held to be a mandatory requirement. Read with Rule 68 of the CGST rule has been held to be a mandatory requirement before the proper officer proceeds to assess the tax liability under section 62 of the CGST Act to the best of his judgment. Stop.
May I, Your Lordship? It is JGST Act, Jharkhand Goods and Service Tax.
JGST Act. A reply to the rejoinder affidavit has also been filed by the respondents. Wherein the averments relating to issuance of DRC 07 have been reiterated, made earlier in the counter affidavit have been reiterated. On being specifically asked, learned counsel for the respondent has not been able to show from the records and records or dispute the contention of the petitioner that no notice under section 46 of the Act was issued prior to passing of the assessment order under section 62 of the Act by the proper officer. Stop. We have considered the submission of learned counsel for the parties and taken note of the materials on record relied upon by the rival parties. For proper appreciation, the relevant provisions of the JGST Act, which are the relevant provisions of the JGST Act, as are necessary to appreciate the issue at hand, are being quoted here under section 16.
62, Your Lordship.
No, 16 also.
Acha, okay.
Eligibility and conditions for taking input tax credit, chapter 5, input tax credit. Section 46 and 47. उसके बाद under chapter 9, returns. Section 51 and proviso. Under chapter 10 relating to payment of tax. Section 62 under chapter 2 assessment. Stop. Rule 68 of the JGST rules are also quoted here. Stop. A perusal of the aforesaid provisions of the Act together with the scheme of the Act indicates that the legislature has provided a mechanism for prior notice to a return defaulter under section 46, where a registered person fails to furnish a return under section 39 or section 44 or section 45. Stop. Such notice is to be furnished in the prescribed format, that is GSTR 3A. Stop. Section 62 makes it all the more clear that assessment of non-filers of return as per best judgment would be undertaken by the proper officer in respect of registered persons who fail to furnish return under section 39 or section 45 after service of a notice under section 46 of the Act, and taking into account after taking into account all the relevant materials which are available or which has been gathered. Stop. Such an assessment order has to be issued within a period of 5 years from the date specified under section 44 for furnishing of the annual return for the financial year for which the tax not paid relates. Stop. Subsection 2 further provides that if a registered person, where a registered person furnishes a valid return within 30 days of the service of the assessment order under subsection 1, the said assessment order shall be deemed to have been withdrawn. But the liability for payment of interest under section 50 subsection 1 or for payment of late fee under section 47 shall continue. Stop. From the materials on record, the requirement of notice before proceeding to make best judgment assessment under section 62 has been consciously laid down by the legislature in the scheme of the under the scheme of the GST regime. So that a defaulter may have an opportunity to file return with late fee in case the return has not been filed within time, so that the consequences arising of so that the penal consequences arising out of non-filing of return within time can be avoided. Stop. There is a salutary purpose for service of notice under section 46 before the proper officer proceeds to make best judgment assessment under section 62 of the Act. Stop. Moreover, subsection 2 thereof further provides that if within 30 days of service of the assessment order a valid return has been filed, the assessment order shall be deemed to have been withdrawn. Stop. The reason being that penal consequences flow out of such an order passed under section 62 of the Act in case the return has not been filed even after proper service of notice under section 46 of the Act, or even after of the Act. Stop. Such has been the case in the present matter, since the petitioner has been imposed a liability of rupees 3 crore 30 lakh 76,800, which includes tax to the tune of rupees 2 crores 88 lakhs, interest of rupees 38 lakhs 88,000 at the rate of interest at the rate of 18% under section 50 of the Act, and penalty under section 73 small 9 73 9 of rupees 3 lakhs 88,800. Stop. Though learned counsel for the petitioner has tried to show serious infirmities in the assessment order passed under section 62 by the proper officer, by the Deputy Commissioner, by the respondent number 2, Deputy Commissioner South Circle Ranchi, and establish that the order is in a format without even referring to the introduction of the facts of the case, the submissions, if any, made by the SSC, no discussion or findings, and no conclusion as to how and why the determination of the tax liability together with interest and penalty has been made. But since the impugned assessment order fails to comply the mandatory requirement of notice under section 46 of the Act, we do not deem it necessary to make any comments thereupon. Stop. The material facts leading up to issuance of the DRC 07 have been referred to in the earlier part of the order. Stop. Respondents have not shown any document to prove that the assessment order was served upon the petitioner. Assessment order Annexure 6 was served upon the petitioner before issuance of DRC 07 on 1st October 2018. Stop. Petitioner has therefore rightly contended that it did not get an opportunity to file its return within 30 days of the assessment order. Had that been the case, the assessment order would be deemed to have been withdrawn. Stop. Learned counsel for the petitioner has also taken a plea that the assessment order has been passed within the extended period of filing returns, that was 31st December 2018 for the period in question. Though anything?
Yes, Your Lordship. 31st December 2018, which is stated in my rejoinder, that was for the purpose of filing return under section 44. That was annual return. However, time and again it was monthly return. GSTR 3B was extended time and again. So let the date may not be mentioned. It may be mentioned that it was extended till 2021 itself.
Petitioner and counsel for the petitioner has also taken a plea that time for filing GSTR 3B return was extended from time to time till 31st August 2021. Of course,
yes,
with late fee, as required under section 44 of the Act.
Under section 39 of the Act.
39, and late fee is under 47.
Yes, Your Lordship.
With late fee under section 47 of the Act. Stop. We need not go into in those issues as we need not go in, we need not comment upon those issues as the impugned assessment order suffers from lack of proper notice. Impugned assessment order passed under section 62 by the respondent number 2 suffers from lack of proper notice under section 46 of the Act. Stop. The impugned action of the respondents has led to blocking of the ITC to the tune of rupees 2.88 crores, which has been adjusted against the disputed tax liability of rupees 3.3076800 imposed under the assessment order. Stop. From perusal of the appellate order at Annexure 9, it appears that the appellate authority has only taken into consideration that the petitioner had failed to file returns within 30 days of the assessment order in terms of section 62(2) of the Act, and therefore the assessment order based on best judgment assessment by the proper officer did not require any interference. Stop. The learned appellate authority has, however, failed to take note that the assessment order itself suffered from serious infirmity in compliance of principles of natural justice and the procedure prescribed under the Act in the absence of a proper notice upon the petitioner. Stop. The impugned action has led to serious penal consequences which cannot be sustained in the lack of such, in view of the serious infirmity in the in view of the serious infirmity in the procedure adopted by the assessment officer. Stop. This court is therefore of the view that the impugned assessment order dated 2nd August 2018, Annexure 6, passed by the respondent number 2, as also the summary of the order contained in DRC 07 dated 1st October 2018, issued by respondent number 3, deserves to be set aside. Accordingly, they are set aside. For the reasons recorded herein above, the appellate order dated 25th January 2020, Annexure 9, passed by the Joint Commissioner of State Tax Appeal, Ranchi Division, also cannot be sustained in the eye of law and on facts. And in the eye of law. Stop. Accordingly, it is set aside. Stop. Petitioner, as also admitted by the respondents, petitioner has filed a return for the period in question. Stop. It is open for the respondents to accept the return or undertake proper scrutiny thereof. Stop. That anything else?
The ITC which has been blocked may kindly be released, and the re-deposit made at the appellate stage.
Consequently, the ITC of to the tune of rupees 2.88 crores. ITC available to the ITC of amounting to rupees 2.88 crores lying blocked shall be released for being availed by the petitioner. Stop. Pre-deposit, you can
Unblocked, may not maybe say that it may be unblocked, which has been blocked. Or the officer will pass the order regarding the unblocking of the same.
It may be unblocked.
for your shall be unblocked. Stop.
Statutory deposit you can take as per the procedure. For that order.
If indicated that line only, Your Lordship, that the statutory pre-deposit may be, that line may be sufficient.
The petitioner submits that the pre-deposit made before the appellate authority may be directed to be released. It is up to the petitioner to approach the appellate authority with proper request, which may be considered as per law. The petition is allowed in the manner and to the extent indicated here.
That's advised, Your Lordship.
Very well. वो उसका बेंच कर दे पता कर लीजिए So,
my lord, I am sorry, my lord, one matter I had mentioned, but due to some network problem in my office, for 5-10 minutes only when the matter was called, I could not be present, neither my colleagues. I think your lordship had kept it next Thursday, that matter, my lord.
Yes. Suits you?
Yes, it would suit me, my lord. I have given the written submissions in those matters, my lord. My friend is there. I thought that I can. It's covered matter, my lord. Actually, my lord, the respondents are proceeding with the assessment in that matter. The final assessment of my assessment year.
That may create further complication.
That may create complication. Otherwise, I am entitled under law to the Form C, my lord. Your lordship, subject to, of course, my lord, the bench convenience, my lord. I am even ready if can be taken up.
No, I have a tied up bench.
Yes,
and
yes.
brother will have single bench for him. So we have kept it on another day.
As your lordship. But if my friends, my lord, may just restrain from the assessment order that's fixed on 3rd itself.
You instruct your officer.
We have also fixed on 3rd.
3rd, yes. Your lordship have fixed it on 3rd, so they have time till 31st March.
Yes.
So they may not just precipitate it or by the assessment order. They have nothing to lose, my lord. They have no prejudice.
We need not say anything. The councils are not present here.
Mr. Pati is here, my lord.
Achha, Mr. Pati is the council. Mr. Pati, you have heard the request. Manage things.
File a time petition there, they will certainly accommodate when the case is fixed on the same day. No officer will proceed to pass an order when the hearing is scheduled before the honorable court. I don't think they will dare to do this kind of thing.
Very well.
As your lord.
Okay.
Obliged, my lord.
Pranam Lordship.
Pranam.
Supplementary for this, under the heading for orders. Item 1, Criminal Appeal, DB number 15553 of 2020. Mr. for the appellant, Mr. Rajesh Sinha, Mr. Sudhir Kumar for the respondent.
May please, Your Lordship. My Lords, in this case, the sole appellant has filed an application for suspension of his sentence, my Lords. Although earlier his prayer was rejected by Your Lordships by order dated 7th of July 2021, my Lords. My Lords, the appellant has been convicted under Section 21C of the NDPS Act and has been sentenced to undergo RI for 10 years along with fine of rupees 1 lakh, my Lords. My Lords, the appellant is in custody since 27/7/2015, my Lords. He has completed almost 6.5 years of custody out of 10 years conviction, my Lords, which will complete after remission only after 7 years, my Lords.
5.2 kilograms.
Yes, my Lords.
Sister, on grounds of custody, we can release him now.
Lordship, he may deposit the fine amount at least.
Yes.
Yes, my Lord.
Learned counsel for the petitioner, Mr. Deepak Kumar, learned SLPP, UVN. On the renewed prayer for suspension of sentence made by this appellant through IA number 461 of 2022. Stop. Sole petitioner stands convicted for the offence punishable under section 21 within bracket small p of the Narcotics, Drugs and Psychotropic Substances Act 1985 and has by impugned judgment dated so and so passed and so by the court of so and so and has been sentenced to undergo rigorous imprisonment for 10 years with a fine of rupees 1 lakh and a default sentence in lieu thereof by the impugned order of sentence dated so and so. Stop. Prayer for suspension of sentence of this appellant was rejected on merit earlier by a coordinate bench of this court by order dated 13th February 2019 after consideration of the materials on the lower court record again on 7 July 2021 by this bench taking into note that petitioner had completed 6 years of custody only since his arrest on 27 July 2015. Then counsel for the petitioner has renewed the prayer primarily on the ground of period of custody of about 6 years and how many months?
6 years, 6.5 years, my Lords.
6.5 years. Stop. Against a sentence of 10 years. It is submitted that petitioner may also be entitled to remission for unblemished period of custody undergone. Stop. Therefore, he may be released on bail on suitable conditions. Learned APP has opposed the prayer. We have considered the submission of learned counsel for the parties and taken note of the grounds urged for release of the petitioner on bail by suspending his sentence. Since the petitioner has already undergone about 6.5 years of custody against a sentence of 10 years, we feel it proper to release him on bail by suspending his sentence, however, subject to deposit of the fine amount in the court below. Stop. 10,002 sureties of like amount each. One of the bailers shall be the deponent of this affidavit, whose ID card, photocopy of the ID card enclosed to the IA be sent to the trial court for necessary verification. Stop. Appellant and his bailer shall not change their address or mobile number without prior permission of the court. Trial court. IA disposed of.
Item 2, Tribunal of Duty number 38 of 2021, Mr. Aman Kumar Rao for the appellant, Mr. Shekhar Sinha for the respondent.
May it please your lordships. Lords, earlier the IA for suspension of sentence was not pressed by the appellant. Now, as per the prosecution case, my lords, if your lordships may kindly have a look to the deposition of the informant, which has been mentioned in paragraph number 8, page 22. Paragraph 8 of the judgment, my lords, will make the case clear. Running page 22 of the
Yes.
Lords, PW1 Kapil Naik, who is informant of this case, he stated in his evidence that occurrence took place on 4/11/2014 at about 7 p.m. and on the said date and time, he along with his wife and son was in his house. He stated that Rajesh Naik, Chotu Naik and Jagdev Naik were standing outside his house. He stated that his son Santosh Naik and Sandeep Naik were also standing outside. He stated that Rajesh Naik called his son Santosh Naik and he heard the sound of fire shot and rushed outside where his younger son Sandeep Naik, the deceased, disclosed him that accused Rajesh Naik has fired upon him. The witness chased the accused persons Rajesh Naik, Jagdev and Chotu, but they fled away. Now, my lords, as per the statement of the informant as well as PW 4 and 6, who are the eyewitness to the occurrence, it was the Rajesh Naik who has shot fire upon the deceased, and no overt act has been alleged as against this appellant, my lords. And another convict, Jagdev Naik, whose case is similarly placed with this appellant, he has been enlarged on bail by this honorable court, my lords. As per the investigating officer also, there are only 3 witnesses, out of which one, Santosh Naik, has not been examined. The other 2, Pradeep and Sushma.
The enmity was with this appellant.
With this appellant, my lords. There was enmity with regard to some land dispute. And that is the reason he has been, though it is the case of the prosecution that the assailant or the other person has got no enmity.
How much period of custody is he inside?
My lords, in para 11, during my lord's trial, he was around 3 months, and after conviction, that is from 13/1/2021.
Then let him remain.
Lords, there is absolutely no evidence as against this appellant to connect him with the crime, save and except the informant who is not the eyewitness to the actual assault. His statement is based on hearsay. The deceased son has informed that it was Rajesh Naik who has shot fire, and no role has been attributed upon this appellant, my lords. And the another co-convict, Jagdev, he is enjoying the privilege of bail, my lords. His
He was
case is
granted
placed.
bail earlier only when you had not pressed your bail application.
My lords,
Bail
that was there.
granted earlier,
My lords, that
and we
is
had
there.
heard you at length before your prayer was not pressed by you. It's not that we did not hear you fully.
That is there, my lords. But your lordships may kindly consider, even if the eyewitnesses account PW4 and 6, their deposition may be looked into. They have also not attributed any role to this appellant, my lords, save and except that he was standing there.
The main enmity was with this person. Rajesh
Might be, my lords. I do admit that there was an enmity. The enmity, my lords, is a sword which goes both ways, my lords.
This time they have suffered. And therefore, about Jagdev Singh, there was nothing of that sort. But
my lords,
regards this appellant,
save and except, my lords may kindly appreciate.
That
if the enmity is taken into account, it may be the reason for false implication also.
No,
it is not the case of the prosecution that this Chotu Naik has hired the other persons for that enmity to commit murder of the son of the deceased. And the enmity was with the informant, my lords, with respect to land. So, what motive have been there to commit the murder of one of the son, my lords? The another son was also present there. No assault was made upon him. It was Rajesh who called one of the son and shot fire upon him. He has not taken pain to commit any overt act upon the another son. If the enmity was with the family,
Rajesh was also a relative, son of Jetsas.
My lords.
So this was all in the family. No hired person was required to be brought.
My lords, the Jetsas, but they were not having any enmity with him.
But
it has also come.
They might, like you find that cousins, agnates in a family, larger family, they are aligned anti against the other part of the family, other members.
My lords.
So this might
be, my lords. But your lordships may kindly appreciate the enmity of the land was with the father, the informant. What purpose could have been solved by killing one of the son? The another son was also present at the place of occurrence as per the prosecution case. But no assault was made upon him. It was only and only the deceased who was shot by Rajesh, and Rajesh called him and shot at him. No attribution upon this appellant, my lords.
We had considered this submission only on the previous date when you did not press it. And the seriousness of his involvement obviously was in our mind. And
as per the postmortem also, my lords, only one injury, which is attributed to Rajesh.
That is true. But he hasn't remained for long in custody. Immediately getting released with a family with whom he has enmity and which has resulted in death. These things are also in the minds.
At best, my lords, I have been convicted with the aid of section 34. Now, my lords, may kindly appreciate, my lords, the recent judgment of the Honorable Supreme Court. The 34, section 34, the common intention has to be proved by the in a very strict manner.
That judgment by Justice Sundaresh.
My lords. The recent, I think it came in the last week itself.
As a last week, no, even before that, there was a very elaborate judgment on the ingredients of section 32.
It has to be proved in a very strict sense that there was a common intention between the parties. Save and except my presence at the place of occurrence, there is absolutely no material to show that there was any common intention. The entire act of assault or whatever, my lords, that has been done by Rajesh.
What was the motive to kill?
Lords, it is for the prosecution to prove. It is not for the defense to prove the motive.
enmity with Chotu Nayak of about 18 acres of land.
My lords.
It was one of the reasons. So let him remain. Then we will consider. You want us to pass an order or does not want to press?
My lords, we will withdraw with some observation as your lordship pleases, my lords. Because again, that would be
Learned counsel for the appellant, Mr. Jitendra Shankar Singh, seeks permission to withdraw the interlocutory application number 539 of 2022 seeking suspension of sentence at this stage. Stop learning. If Mrs. Priya
Yes, Your Lord.
does not oppose the prayer in view of the request made, IE number so and so is dismissed as withdrawn. At this stage,
My name may appear in the cause list, Your Lordship.
if the name of Mrs. Priya's rest appear in the cause list.
Right. Item number 3, civil review number 40 of the parliament. Ms. Rajita Sinha for the police line. Mr. Gautam Rakesh for the
Anyone appearing for the parties? Yeah, why it has come? Subsistence allowance. Who is for the railways?
Now, railways will be represented by the ASG office.
No, Mr. Gautam Rakesh has been appearing for
My lord, now another notification has come, my lord. Now all the railway panel has been, matters has been transferred to the ASG office, my lord. And therefore, because of this reason, my lord, perhaps just
in a civil review matter, the petitioner is asking for an further direction to pay allowance. First of all, whether civil review would be entertainable or not.
yes, my lord.
Simply passed over for the day.
Yes.
Already the items of contempt civil court to October 2021. Mr. Pramod Kumar Sinha for the police line. Mr. Ravi Chandran for the police line.
लिस्ट में इंडिकेट किया हुआ है ना 15 और अर्लियर.
Even after the last date, my lord, they have not passed any order. Not they have filed any so-called. On the last occasion, my lord, counsel for the state, my lord, has submitted before your lordship, my lord, that they are going to pass the order within a day or two. My anxiety is, my lord, they are just victimizing me. They have sealed the premises. They have not acted even as per the provisions of Excise Act. They have not made any inventory of the articles and taken it to the JSBCL on that at that time. Until date, my lord, I have to make payment of the even rent of that premises. They are not taking any decision. They are keeping the matter pending. And moreover, my lord, in the so-called, they have filed the notice they have given. My lord, that is quite contrary to the order passed by this honorable. Because of this reason, my lord, on the last occasion, Piyush Chitres was appearing, my lord, on behalf of the state. He has submitted that we are going to pass order within a day or two.
ये मिस्टर पीयूष चित्रेश, ये बेंच में चल रहा था, फिर यहाँ आगे टाइड अप करते हैं। Then we keep it on some other day.
Lordship, non-appearance of the opposite party may be recorded and the order be communicated to the learned advocate general to ensure their appearance. Because they are trying to unnecessarily delay the matter.
They are just trying to complete this 31st March.
We can communicate the order to the Deputy Commissioner also.
Yes, Lordship.
Yes, Mr. Chitres.
Yes, my lord. My apologies, my lord. Lord, I was seeking for 2 weeks more time, Lord, for filing a supplementary show cause. We are under process of scrutinizing the reply filed by the petitioner, Lord, and we'll be passing a recent order, Lord, soon, Lord.
So you will be filing the compliance report?
Yes, Lord. We'll pass a recent order, Lord, as per the direction of this honorable court, Lord.
You are aware that you have been taking more than...
My lords, I'm aware, my lords, I'm aware that there is a delay on my part, my lords, I'm aware of that, my lords. I've spoken to the officials, my lords, they have assured me within 2 weeks, my lords, they'll be taking a decision, my lords. You know, they have sent a file to the office of the London Advocate General for some opinion, my lords, for clarification, my lords, so it took some time, my lords. As the last injunction, my lords, 2 weeks may be granted, my lords, we'll be filing a compliance report, my lords.
Time has been granted.
May I submit one thing, my lord?
To show cause again and again. But despite sufficient time, opposite party concerned has not filed the supplementary show cause. Then AC to AG Mr. Piyush Chitres has prayed for further 2 weeks' time. Stop. He submits that the concerned authority is in the process of taking a decision after scrutiny of the petitioner's representation. 10 days more time is allowed. The matter is adjourned for 10 days more time is allowed to the opposite parties to filed supplementary show cause compliance, failing which the opposite party concerned, namely, who is to pass the order?
My lord, it is the Deputy Commissioner, my lord. Ranchi.
Deputy Commissioner Ranchi.
Yes, sir.
He is the person who had cancelled the. He is the officer who had earlier cancelled the license.
Yes, my lord. Connection 5 is cancelled by him only.
5.
Sorry, OP number 5 was the officer, my lord, who has passed the order for cancellation of my license, my lord.
And was communicated by OP number 6.
Yes, my lord.
OP number 5 and 6 shall appear in person on the next day. The matter will be listed on 7th March.
7th March.
Yes.
Pranam Lordship.